Hi everyone, today is April 17th, 2020. So happy Friday to you all. I hope everyone is continuing to remain at home, safe with their families, and following the guidance and guidelines of your elected officials, no matter where you live in the United States and across the world. Today I want to briefly talk about a recent change to the immigration laws here in the United States as they pertain to the public charge ground of inadmissibility. Back in August of 2019, the Trump administration, through the Department of Homeland Security, issued final rules dramatically changing the assessment of the public charge ground of inadmissibility. Initially, 5 district courts across the United States enjoined the implementation of these final rules, but lo and behold, several weeks thereafter, the United States Supreme Court lifted that injunction, and now it applies across the 50 states. Yes, folks, that is our U.S. Supreme Court. Unfortunate, but it is what it is, and we now have to deal with it. These changes are not to be taken lightly. They dramatically change the definition of public charge. And now, these changes are only going to apply, so listen carefully, to adjustment of status applications that were filed on or after February 24th, 2020. So those of you who have pending adjustment of status applications that were filed before February 24th do not need to worry about these changes. This is only for people who filed after the 24th of February. What has happened here is that the focus has shifted from the petitioner who filed the affidavit of support on behalf of the applicant to the applicant him or herself. Previously, if the petitioner had adequate income, they qualified, and the inquiry stopped there. Today, things have changed dramatically. The inquiry is now shifted to the applicant, and there are certain subjective factors that are going to be taken into consideration. And these subjective factors are very, very disturbing, at least to me. So now USCIS will look to the applicant's age, to their level of education, their ability or lack thereof to obtain employment, their skill set, their credit worthiness, their health condition, etc. They're going to be looking at every detail of an applicant's life. And this is going to create a huge burden and obstacle on many, many people who are low-skilled, low-income, undereducated, the elderly, those with disabilities, those with health conditions, and the list goes on. It is going to be very difficult to overcome a public charge finding. So my advice to you is please, before filing your adjustment of status application, consult with an immigration professional. Please call either myself or my office at 708-233-1122 or email us at www.immigrationjd.com. That's our website, and you can find our email information there. We would be very happy to answer any public charge related questions for you. Now, I'm going to shift my remarks to how this change in the public charge definition may or may not affect your wanting to apply for certain benefits under the COVID-19 relief package. I've been getting many questions from people that are concerned about whether or not getting a stimulus check or applying for a loan or getting treatment will affect their immigration case. So the first question relates to getting tested or treatment related to COVID-19, whether or not getting emergency medical treatment or a test will affect the immigration filing. Well, fortunately, the answer to that is no. So please don't let anything prevent you from getting tested or getting treatment if you have contracted or think you may have contracted the COVID-19 virus. Another question relates to unemployment insurance benefits. Will getting unemployment insurance benefits affect an application for permanent residence? The answer to that question is also no. Again, people, this is not a handout from the government. This is your hard-earned tax dollars coming back to you. If you qualify for unemployment insurance benefits, please file for them and take them. It will not affect your immigration application. The third question relates to the stimulus check that many people have received already in the form of a direct deposit or are continuing to look out for in their mailboxes. That is a tax credit, and DHS and USCIS has been very clear that tax credits do not figure into the analysis of whether or not you will become a public charge. So getting that stimulus check, if you qualify, again, will not affect any pending or future applications for adjustment of status. So there you have it, some good news. If you have any questions, again, related to the public charge provisions, please give us a call or look us up at www.immigrationjd.com. In the meantime, please continue to stay safe, and we will hopefully see you and talk to you soon. Take care.